let's see the next topic that we have. So Unit 5, two legislations are there as we mentioned. Second one that we have is Probation of Offenders Act. Okay, so we will see what this legislation is all about. This legislation that we have is Probation of Offenders Act. So now what is probation? Probation is nothing but release of offender from detention. Otherwise, it happens that once a person commits a crime, whether it's IPC or some other legislation, punishment is also being mentioned there. That maximum 3 years, maximum 5 years, whatever is the punishment, based on that the person should ideally be punished. But sometimes it might happen that because already the prisons are overcrowded, right? And sometimes it may happen that a person, because of the situation or something, he just ends up committing a crime. Might be he is otherwise a good person. He is otherwise not belonging to any like criminal background. He is not having, might be he is otherwise having like a very good record. Okay, because of situation or something, he just ended up committing a crime. In such cases, okay, in such cases, rather than sending that person in prison, because anyways, in Indian legal system, main aim is to reform the person, right? Like we say, hate the sin, not the sinner, because the person commits a crime based on the situation. He is not born a criminal. So we say that there is always a possibility that we can reform a person. So why to send a person to the prison if he is someone who is otherwise a good person, doing everything good, no criminal record, no previous offenses, nothing? In such a case, why can't we, release the person? So that provision is given under this legislation, Probation of Offenders Act. Even if some offense is being committed, probation can be granted. And what is probation? It is nothing but release of offender from detention. Otherwise, the law says that yes, this person should be detained for 5 years, 10 years, 2 years, 2 months, whatever. Can we release the person or not? If we can, what all other situations or conditions under which we can release such a person? That provision is given under this legislation. Okay, legislation of 1958.
Yes.
And if you remember, we had discussed one topic before also, which is this one, security for keeping peace and good behavior.
Yes, I remember, madam.
You remember, right? Like just like bond agreement, they would sign a bond wherein they would say that, okay, I would maintain good behavior, I will do this, I will maintain peace and everything. And this is also something which comes into picture over here for this legislation. Okay, now as we say, hate the crime, not the criminal, because we believe that a person is not born as a criminal. Because of the situation, he ends up committing a crime. And that is why we want to eliminate the crime. We don't want to eliminate the criminal. That's why death penalty is given only in rarest of rare cases, because we feel that there is always a possibility that the criminal can reform himself. Right? So criminal law in India is mostly focusing on reforming the offenders rather than punishing them. Punishment, the main purpose is again to reform the person. If there is already a possibility that we can reform him without even punishing, why not take that option rather than overcrowding the prisons and everything, right? It is true that punishment gives a sense of satisfaction to the society. Definitely, when the criminal is punished, society would feel that, okay, fine, this criminal got punished, law prevails. But even after that, and also the victim would feel satisfied that, okay, he had committed some crime, he has got the punishment. But even though it leads to a sense of satisfaction, we also need to consider that prisons are overcrowded and it incurs a cost on the government also to maintain them, right? So in such a case, if it is possible, why can't we probate the offender? So instead of keeping the accused with other criminals who are like maybe habitual offenders or maybe some serious criminals, because this person would mingle with all those people, there is a possibility that his mindset might also change. Rather than reformation, he may, on the other hand, become like them only. His mindset might change. And also when a person remains in prison for months and years altogether, it becomes very difficult for him to again go back to the society and adjust, right? So in such a situation, why can't we probate the offender? That is what this entire legislation is all about. So this is based on this reformative approach that we anyways have as a theory of punishment. Also, we want to reform the criminal. When we look at the legislation, it's a very small legislation. Okay, it's a very small legislation. Let me open the barrect also. Yeah, so this is the legislation having only 19 sections. Okay, and the first initial sections are the ones which are very much important. So what is this entire legislation all about? Definitely first one is like the title of the legislation and all of that. Secondly, it talks about application. So what do you think about the application of this legislation? Where is it applicable?
Is applicable all over the country?
It is applicable to the whole of India. Even in Jammu and Kashmir also it is applicable, as well as Ladakh. Okay, so this legislation is applicable in whole of India. Then it provides for some definitions like code. Whenever they are mentioning code, it means the criminal procedure code, because we are talking about punishments under criminal procedure code. Probation officer means an officer appointed to be a probation officer or recognized as such. So some persons are appointed as probation officers who would do the needful, and they are considered as probation officers. So it is also given under section 13 of the legislation. This is what probation officer is. A person who is appointed as a probation officer by state government or recognized as a probation officer by state government. A person provided for this purpose by a society recognized in this behalf by the state government. In an exceptional case, any other person who in the opinion of the court is fit to act as a probation officer because of some special situations, they also may be considered. Then words and express, whatever is used, this is like in reference to code of criminal procedure, right? What is not defined in this act, we can take help of criminal procedure code, because this is like it adds on to the provisions of CRPC, right? So these are few definitions which are being given here, and after that the proper provisions start. So section 3 that we have under this legislation talks about power of court to release certain offenders after admonition. When a person commits a crime, okay, so there are certain crimes where it is possible that what you do is you give a kind of warning to the person. You warn the person that what you have done is very wrong, it is a crime, and this could have been the punishment. But because of some prevailing situations and everything, you are being released. You are not sent to the prison, right? So person is given a warning that what you have done is otherwise very bad. Otherwise, it is a crime. You could have faced this much of punishment, but only because of some prevailing situations, you escape the punishment. Okay, so you should rather be very careful next time. That is what this provision is all about. But now in which all cases or situations can we actually say that this, like a person may be released by simply giving a warning? That is mentioned under section 3 of the legislation. Okay, so it mentions that when any person is found guilty, having committed an offense.
In legal,
sorry?
Madam, in legal terms, such a warning is termed as admonition.
Yes.
Okay.
Yes, admonition or warning can be given by the court, and person may be released. That because of some prevailing situation, because you have committed the crime for the first time, or might be it is something where it can be granted, we are releasing you, but otherwise you should be careful, like that warning may be given. So this is applicable in some offenses, not like in every case it can be done. Where can it be done? There are some offenses which are not considered as like very serious or something. Okay, so that for that provisions are being mentioned. So there are certain offenses wherein sections are being mentioned. Like take for example 379 of IPC, which relates to theft. Maximum punishment is some 3 years. We have section 380, section 381, theft by clerk, theft in dwelling house, section 404, dishonest misappropriation of property, section 420, cheating and dishonestly inducing delivery of property. Even though punishment might be different, like in this one 420, it's maximum of 7 years. But even then court considers, or court may consider, depending on other situations prevailing, that this is something where probation can be granted. Okay, it just happened by the person. Maybe he is not a habitual offender, or he's not having a criminal record, or otherwise he is not bad. Because of some prevailing situations, he ended up committing the crime. So all these sections, if a crime is committed under these sections of IPC, or any offense punishable with imprisonment not more than 2 years, or with fine, or with both. If punishment is not more than 2 years of imprisonment, right, even if it is with fine, lesser than 2 years punishment, or with both, whatever, in such cases, okay, even though it is under IPC or some other legislation, and there is no previous conviction, the person is not being convicted previously, has not committed any kind of crime, it is proved against him, the court by which the person is found guilty. If the case was filed in magistrate court, then magistrate court would take the decision that, okay, fine, we have found him guilty, but having regard to the circumstances of the case, considering the other situations, other circumstances of the case, plus nature of the offense, plus character of the offender, everything, considering every single thing, what we have found is that it would be better. Okay, it would be better that instead of sentencing him to imprisonment or releasing him on probation, good conduct under section 4, releasing him after due. We do not even want to sign a bond that you need to maintain good behavior or something, but we can straight away release the person, giving a warning. Okay, it might happen mostly in case of theft and all. Okay, like a person has committed theft in dwelling house, case was filed, and he might say that, okay, because of COVID, I was not having anything to eat, so I ended up committing this crime, and I do not have any kind of criminal record or anything. Their court might say that, okay, fine, because of the situation and everything taken into consideration, we are giving you a warning that whatever might be the situation, that do not give you a liberty to commit an offense. So they might consider that it is better that we release the person, taking into consideration the situation under which the person committed the crime. Okay, so in section 3, it applies in case of these offenses where sections are mentioned, or anything where punishment is lesser than 2 years, or with fine, or with both. Court may release the person after giving warning, considering the situation, nature of the offender, etc. Okay, is it clear?
Clear, madam.
So this is about section 3. Simply person will be released based on the warning which should be given. Now, section 4 is a little bit different. How is it different? Because this is related to the other topic which we discussed, security for keeping peace and good behavior. Okay, power of court to release certain offenders on probation of good conduct. Only when they make a promise of good conduct and they agree to the conditions which are there on the bond, then only the person will be released. It's not like a simple warning and then release the person, but rather they need to agree that yes, whatever is written here, I will follow that. This is section 4. When any person is found guilty of having committed an offense, here punishment is more. There it was just like lesser than 2 years, but here it says punishable, not punishable with death or imprisonment for life. That means it might also include crimes which are punishable with imprisonment for 10 years. So if punishment is 10 years, it's a severe crime, right? So in such cases also, this provision may be applicable. The court by which the person is found guilty, if the case was filed in magistrate court, then magistrate court is having the power. If it was decided by sessions court, then sessions court is having the power. So what they would do, having regard to the circumstances of the case, including nature of the offense, character of the offender, same things would be taken into consideration, just like section 3. Taking all these things into consideration, court might feel that it would be better to release him on probation of good conduct, on the agreement that he will maintain good conduct and all these things. On that condition, he may be released. It would be better to release the person considering all these other situations. Instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or without sureties. It depends on the court. Court would put, just like how in case of a bail, bond conditions may be put by the court depending on the situation and everything. Here also, depending on the situation and all those situations taken into consideration, court would decide what would be the conditions. But court would ask him to enter into a bond, and based on that, the person may be released. Okay, court might say that, okay, you need to appear here, you need to do this, do that. Some conditions might be there. And in case of this bond, it would be not exceeding 3 years, for which he would be given he need to sign that, okay, for this duration, I will follow these instructions, whatever is written in the bond. And in the meantime, keep peace and good behavior, just like that other provisions which we discussed under CRPC. That's why here they have not given in detail. They are just mentioning in which all kinds of crimes it may be applicable, because it's already mentioned in CRPC. Provided that the court shall not direct such release of offender unless it is satisfied that the offender or his surety, if any, has a fixed place of regular occupation. So it should happen that they are living in a certain specified place, okay, and court exercises jurisdiction, or in which the offender is likely to live during this period he enters into the bond. It should not happen that person puts his signature and then he only escapes, he only goes somewhere. That should not happen. If it happens that the person is living in this certain territory which is under court's jurisdiction, he is maybe working in some office there, then it would be very easy for the court to keep an eye on the person also, right? What kind of a behavior he is maintaining, everything, it would be in front of the court. So considering all those situations, court may decide that, okay, fine, this person may be released on signing of a bond agreement to maintain peace and good behavior. Okay. So you need to remember this part. Otherwise, these two provisions look similar. In one, straight away with a warning, person will be released. And what all things would be seen? Nature of the offense, character of offender, and the circumstances of the case. These are the three things that will be seen. But here punishment is offenses which are not punishable with death or imprisonment for life. Yeah. But here we have some specific sections mentioned where punishment may be even more. But otherwise, in general, it is imprisonment for not more than 2 years.
2 years.
Or with fine or with both. But in these cases, it is even more than 2 years. That's why these sections are specifically mentioned. Okay, so same things would be taken into consideration by the court, and then court may release the person. Now, supervision order may also be passed. Fine, the person agreed that, okay, fine, I'm not doing anything wrong. I will maintain good behavior. I will maintain peace. But is he actually doing that or not? For that, supervision order may also be passed, that you supervise, you see what this person is doing. Is he straight away going to office, coming back home, maintaining peace, or is he doing something in between? is it disturbing peace or something, right? For that, supervision order might also be passed, not being less than 1 year. That for this duration, you need to keep an eye on this person. Like that also, order may be passed. And whatever bond they would agree, right? It may be with or without sureties that someone else also signs. Based on that, conditions are put, what conditions will be put, all these things would be taken into consideration by the court depending on the situation. Okay, so some additional conditions also might be put. Court is basically free because court, while the case is tried, entire process, court would know a lot about the person and the situations prevailing. Based on that, court would take a decision what steps would be better. Okay, like if someone was committing a crime, creating disturbance because of the impact of intoxication or something, he might be ordered that you need to abstain from intoxicants. Whatever is required as per court, those will be done. Okay, so probation on good conduct. Only when the person promises that, yes, I will maintain peace in the society, I will maintain good behavior, only in such a case the person can be released, otherwise not. He needs to agree to the conditions.
Yes.
Okay, next section is cost and compensation. If any person is released, okay, under section 3 or 4, maybe he is released only with a warning, or maybe he is released after signing a bond. Even then, the court might order, okay, that, okay, fine, because it was your first crime, otherwise you are a good human being, so we are releasing you on signing of this bond. But that does not mean you are completely free. Okay, court might order, even though he was otherwise released, court might still order. What order may be put? The offender to pay compensation to the victim for loss or injury that is occurred by him. Court may still say that even though you are released, the person has suffered harm, so you need to pay compensation. It might be in 420 and all, right? You have committed the offense of cheating, and other person ended up suffering harm, so you need to pay compensation. After that, you may be released. Cost of proceedings as the court may think reasonable. In order to carry out this entire proceeding, the plaintiff has incurred some cost, right? Cost of the suit, that also you need to bear, you need to pay that amount also, because this person has already, he was a victim in a cheating case. After that, again, he had to spend money to continue with this court case. So for that also you need to pay the cost as well, cost of proceedings. Okay.
Yes.
Now, this are mostly applicable when offenders are like young person, okay, not like a child or a juvenile, but below 21 years of age. When a criminal is below 21 years of age, there is a possibility again that they might get easily manipulated by someone, right? They have their entire life in front of them, right? Early in their 20s, if they go to jail, it might become very difficult for them to again adjust in the society and do something good. That society might not accept that, and they might face some difficulty. So there is a specific provision given for offenders who are below the age of 21 years of age.
Yeah.
That is given in section 6. It talks about the restriction on imprisonment of offenders under 21 years of age. This provision says that offenders who are under 21 years of age are not sent to prison where the offense is not so serious as to warrant imprisonment for life or death. If it is something which is less serious, like the other one we have discussed, right? Other section for good behavior. Similarly, if it is something where punishment is lesser than imprisonment for life or death, in such cases, we should try not to send these kind of young criminals to the prison, because there is a possibility that they would mingle with other criminals and they might become criminals as well. There is high possibility for that. So in case where accused is below 21 years of age, what we can do is they can call for report of probation officer. If the court's opinion is not desirable, if the court's opinion is not desirable, the offender either on the ground that he's given a warning, or maybe he has to sign a bond, whatever court feels, the court can pass sentence of imprisonment on the offender who is under 21 years. 21. One second, I'll just open from here. Okay, so power of court to require release of offenders, this we have done. Restrictions on imprisonment when offender is below 21 years of age. Okay, where any person is under 21 years of age and they have committed a crime, they are found guilty also for an offense which is punishable with imprisonment, but not imprisonment for life, but lesser than that. The court by which the person was found guilty, whether it was magistrate court, whether it was sessions court, whatever is the court, shall not sentence him to imprisonment unless it is satisfied that, considering the circumstances, again same things would be considered: circumstances of the case, nature of the offense, character of the offender. Considering these things, it would not be desirable to deal with him under section 3 and 4. Court comes to the conclusion that it's not a good decision to release this person with a warning or with signing a bond. And if the court passes any sentence of imprisonment on the offender, it shall record the reasons also. But court says that no, considering all the situations and everything, we have come to the conclusion that it would not be a good decision if we are releasing him on warning or on a bond, but we need to send him to the prison only. But why is the court doing it? For that, court needs to write the reasons also. What is the reason? Is it that he is having like a criminal mindset? What is the situation? Like that, court would record, and after that, court can take a decision. Okay.
Yes.
For the purpose of satisfying itself, whether it would not be desirable to deal under section 3 or 4 with an offender, the court shall call for a report from the probation officer and consider the report. Probation officer would also give their point of view and everything, if any, and any other information available relating to character, physical and mental condition of the offender. What is the situation prevailing? Everything will be taken into consideration, and after that, court will take a decision whether we can release this person or it would be risky for the society in general. Okay. So this is applicable for offenders who are below the age of 21 years of age. Okay, first one we have is offender where it is possible that we simply give a warning and release the person for offenses punishable with lesser than 2 years, or maybe these theft, cheating, and these kind of offenses. Probation for peace and good behavior. Here again, punishment is lesser than death or imprisonment for life. It is applicable.
Yes.
Report of probation officer to be confidential. The report of a probation officer, which will be written and submitted, shall be treated as confidential, provided that the court may, if it thinks fit, communicate the substance thereof to the offender. Otherwise, it would be a confidential report. Court would only take into consideration what is written, after that take a decision. As such, all the other copies, documents relating to the case would be given to the criminal also, but this report would not be given. It is maintained as confidential. But if needed, what is the substance, what is written, the main points may be communicated to the offender and may give him an opportunity of producing such evidence as may be relevant to the matter, whatever is stated. If the probation officer has written something that might be he was having a previous history of doing this kind of a thing, maybe case was not registered, the person may be given a chance that, okay, this is something which has come in the report. Can you give some evidence or any clarification for that? That also might be done.
Yes.